The next two segments of the conference are dealing with what we call transnationalism versus sovereignty in the international digital political economy. So we have three interesting, two papers actually, and one sort of a report or discussion. We'll start with Elena Plexida from ICANN, and she is in a very interesting position, working for ICANN in Brussels. And as you probably know, ICANN is the, I don't know if they like to be called this or not, but the Global Governance Agency for Internet Identifiers, and very much wants to maintain a global perspective, and European authority in this area has been inserted in ways that created some tensions with ICANN. So I will let Elena explain that, and thank you very much for being here, Elena. We really appreciate it, and we'll let you take it over now.
Thank you so much, Milton. And thank you all for having me. I hope you can hear me okay. I'm not an academic, as Milton just explained. I work for the government and IGO engagement team of ICANN. And I myself have a governmental background. I come from a government, including having worked in Brussels bubble before joining ICANN. So I worked as a telecom attaché in the council. And then I spent 3 years with the European Commission. As Milton said, ICANN, as you're very well aware, coordinates the so-called Internet unique identifiers, the numbers, the names, the protocols. We are not alone in this. We do that together with our technical partners, such as the regional Internet registries that manage the IP addresses in their respective regions, or the IETF that makes the protocols. As long as you have one set of identifiers globally, you have one internet. That's our basic mission. Milton said that as well. In that regard, our mission is to ensure that at technical level, the internet is accessible to anyone, anywhere. Now, the names, the numbers, they do not recognize borders, and their global interoperability needs to remain intact for the internet to work. That's why the governance remains outside the sovereign system. The governance was entrusted to the global multi-stakeholder community, which includes everyone, governments, industry, academia, you name it. And that's, if I may say so, I mean, governance of the identifiers is core or hardcore internet governance, if I'm allowed to say that. Internet governance as defined today, at least. I know we're discussing whether and how it should be redefined. And I'm saying it is core or hardcore internet governance because in comparison with most other areas that the internet governance has expanded to, when it comes to governance of the identifiers, there is policy making, decisions that are then applied on the identifiers themselves globally. In the case of ICANN and the DNS, the ICANN community decisions become policies that can even change things like the very root zone of the DNS, else referred as the root of the internet. That's why I'm saying it's hardcore internet governance. The other part of it is that the period in communications evolution that gave rise to the internet was a period that everything was becoming global. We were moving from nations to globalization. And that spirit is reflected both in the internet itself as an invention. It's permissionless, it's open to all, and in its governance. Well, that said, the world is not the same place anymore today. There is tension between international actors. We do not really like globalization as we used to. Sometimes I'm not sure we like free trade anymore even. In effect, we're starting to see tensions between global governance systems, such as the one ICANN coordinates, and national sovereignty. We're starting to see efforts to reassert or assert territorial authority of a nation-state style, even in areas that have been left intentionally, and for good reasons, if you ask me, outside sovereignty, such as the identifiers. I was asked to speak about what we're observing in Europe. A number of legislative initiatives are currently coming out of Europe and are setting Europe in a leadership role as regards affecting similar digital initiatives in other parts of the world. Examples are the GDPR, the Copyright Directive, the Digital Services Act, the Digital Markets Act. Those initiatives affect the application layer primarily. They have to do with what happens on top of the internet's technical layer. Those are not the initiatives I will focus on, therefore. In fact, so far at least, any impact that such EU initiatives have had on the technical protocols and standards that ensure an interoperable internet has been indirect, has been unintentional, and in most cases, it has been avoided once identified. To give you an example, the e-privacy directive, which was about bringing GDPR into the technical sphere, generally speaking. As proposed at first, it included a very well-intended provision about cookies to give the ownership of cookies back to the users. But as written, it was not technically sound, and it would have tampered with routing. It was changed as soon as it was brought to the attention of policymakers. Now, lately, nevertheless, the EU has started contemplating initiatives that directly target the identifiers, and specifically the domain name system. The most prominent example is the proposed second edition of the Network and Information Security Directive, NIS2. This directive is about imposing cybersecurity measures and reporting obligations on operators of essential and important services. So the Commission was proposing to renew the existing NIS1 directive, if you will, into what became known as NIS2. Actually, now it is almost adopted, it's almost done. The original proposal included regulatory measures on the root server system, so the core of the DNS. This suggestion did not go through, just to be clear. But let's unpack that. The root zone file is managed by the Internet Assigned Names Authority, the so-called IANA, which sits with ICANN, along with other key functions related to the global coordination of the DNS. The service, and by service I mean pushing the root zone for machines around the world to be able to use it for DNS resolution, is offered by 12 independent organizations, including one that is here in the Netherlands, right? And the root service is offered by these organizations voluntarily for the greater good of internet users, not for revenue. In 2016, we had the IANA transition, which you can say really fulfilled the vision of a multi-stakeholder approach to governing the identifiers. And the EU at the time has been pivotal and a key contributor in making that happen. So now suggesting imposing unilateral regulatory obligations on IANA seems to be contrary to this approach, seems to be contrary to the multi-stakeholder approach that otherwise the EU keeps saying that it champions. I'll quote the words of the lead parliamentarian on this specific directive, NIS2. On behalf of the European Parliament, this MEP was leading the negotiations. Mr. Gurtheus, I'm sorry, I cannot pronounce no matter how hard that cried. He's a Dutch MEP, by the way. So in his report, he put that regulating the root servers seems to be contrary to the EU's vision for a single, open, neutral, and unfragmented network, and could empower states advocating for a state-controlled internet governance approach. That as regards the effect of the multi-stakeholder approach on the moving to more sovereign approaches. I also have to note that from cybersecurity standpoint, and NIS2 was addressing cybersecurity concerns, right? Including the root services in the application of NIS2 would not improve anything, especially something that already works. And I'm saying that because the root service has operated without any glitch since the creation of the DNS in mid-1980s. And that's because there is so much resiliency in the DNS. On the contrary, regulating the root service in that way would have risked having the exact opposite effect, as the operators that are in the space, who, as I said, they offer the service on a voluntary basis for the greater good, might have chosen to actually pull back and reduce the instances that they operate. If they had chosen to pull back because they're being regulated and they are open to risks and liability and fines, that could only have hurt the resilience of the DNS, because the resilience of the DNS is depending basically on sheer numbers. There are so many machines propagating the root that there is no way something can go wrong, even if many of them go down. As I said, the suggestion did not go through. The European Commission, though, insisted on the inclusion of root servers until the very end in NIS2. Commissioner Breton, who, as you might know, is the Commissioner for Digital Matters, when he addressed the member states ministers in the council meeting that adopted the council position on the matter, raised two issues with the ministers. So out of all the changes that the council made on the commission proposal, he came back to two of them. One was that they did not accept to include the public administrations in the cybersecurity measures. I get it, it's political. The second was the root servers. And he said that those stakeholders that insisted on the non-inclusion of the root service, those of course would be ICANN, ISO, the root server operators, the technical community overall, do not have the interests of Europe at heart. I repeat, the statement was that they do not have the interests of Europe at heart. This phrase and the insistence, if you will, tells me, A, there is a fundamental misunderstanding of how the DNS works. The DNS is a global thing. And B, and more importantly, that the DNS is viewed as a geopolitical issue. It is becoming for Europe part of the geopolitical agenda. That conclusion, if you will, could be confirmed or reinforced further if you look at NIS2 in combination with other initiatives. The DNS for EU initiative. So Europe feels it has to have its own public resolver. And in combination with the EU cybersecurity strategy, which puts forward the idea that there needs to be a contingency plan for the root of the DNS. I have to say for the latter, the contingency plan, there are not more details put forward yet, aside the general idea. And the strategy notes the intention to work with the multi-stakeholder community in that regard. But again, my point is, if you look at them as a totality, you might come to the same conclusion as I just mentioned before, that DNS is becoming a geopolitical thing. While we're at NIS2, and let me change the subject, I'm moving from the root service to another part that was in NIS2. I would be remiss not to mention the provisions relating to registration data, the famous quiz. Don't worry, I will not get you bogged down with the details of the long quiz debate. As I'm sure you're aware, since the enactment of the GDPR, the ICANN community has been working on an updated quiz policy. The work is taking place in different phases. The challenge here is that this work is related to compliance with the law, the GDPR, that is not exactly crystal clear, if I can put it that way. And that's intentional, the GDPR, right? To offer to different industries and different businesses the space to adapt in a way that suits them. The fact that there are parts of the GDPR that are not clear, though, is not helping really the ICANN community. So the ICANN community is a technical community, is not there to interpret the law. That's not within, nor should it be within its mandate. It's there to make policies about the DNS, specifically the GPLVs. So the point I'm trying to make about NIS2 and the provisions on quiz, to the extent that these provisions would have offered clarity as to the application of the GDPR to the registration data, these provisions would have been helpful to the ICANN policy development processes. Could have been complementary in the way of answering ambiguities relating to the law that, as I said, the community cannot do. Little has been achieved in that regard in NIS2 as finally adopted. Some is there, I have to say, but not something that substantial or groundbreaking. Instead, the point I want to make, what happened is that the final text is instead of limiting itself in offering the much needed legal clarity, seems to be intruding into the ICANN policy making. What I mean, for instance, the member states, when they transpose the directive, this is a directive, right? To become effective, member states have to put in place national legislation. So when they put in place this national legislation, they will have to put in place not only the obligation to collect whose data, but most likely, and depending on the legal system in each country, detail which fields to be collected as well. So not only the obligation, but also details about which fields. This is essentially the ICANN policy making. So in effect, we might have 27 registration data policies plus the ICANN ones that apply globally for GTLDs. So, as I said, this part of the ICANN policy making will be taken over by the legislator. Plus, if and to the extent that national registration data policies differ from the global ones and they differ from each other, we might end up see fragmentation as well in that regard. Let me shift to another legislative initiative, two actually that are now ongoing. For a more recent example, when we see draft legislation having the potential to take over bits and pieces of the ICANN policy making. There are two proposed regulations right now under negotiation in Brussels on geographical indications protections. There are two because there is one on food and agriculture protections, so things like feta cheese, and another one that is about craft products. I think an example of that should be the Murano glass. So there existed protections for things as feta, but not for things as Murano glass, and now they're trying to make sure that also these are protected. Now, these two separate proposals included the protection of the GIs in the domain names as well, with the creation of an information and alert system for European CCTLDs. So European CCTLDs and only European CCTLDs at the original proposal would have to provide information and data in the possession necessary to run the system. So far, so good. Nevertheless, latest edits from the council, so from the council debates, the text that is coming out, and again, this is still under discussion, extended the obligation to protect GIs in domain names to all TLDs established in the Union. So not only CCTLDs, which are, by the way, outside the ICANN policy making, but to GTLDs. And similarly, they extended to all TLDs the obligation to ensure that any alternative dispute resolution procedures shall recognize geographical indications. Now, what is the catch or what I'm trying to say? The ICANN dispute resolution mechanisms, the ones that are there, the UDRP and the URS, they do not cover geographical indications as the two regulations now under discussion, I'm trying to say. And why they don't? That's because the whole world really is not seeing eye to eye on what is or what is not a geographical indication, and the whole world does not accept that geographical indications are intellectual property necessarily. So, and actually there is work going on in that regard in WIPO for a number of years, I should know, where truthfully is the place to agree on a global level on GIs. Well, at the same time, there is policy work happening in this area within ICANN, and so one could argue this would create or risk conflicts. What I mean, in the sense that putting in place legislation about the protection of GIs in generic domains can preempt developments within ICANN and elsewhere. Of course, I imagine this is the idea there. So they can preempt developments, or they can render developments within ICANN irrelevant and effectively bypass them with stakeholder model. Another interesting area, and I will finish with that, I promise, is standard setting. The EU has contemplated initiatives relating to standard setting that, if adopted, would bypass existing global standards development processes. An example that I would like to bring to your attention is the EIDAS second version. EIDAS is the regulation for electronic identification schemes in Europe. The draft rulemaking is proposing to force web browser vendors to recognize a digital artifact called QAC, Qualified Website Authentication Certificate. These QACs aim to achieve a laudable, otherwise, goal. They are a reliable ID card for use on the internet. But because Etsy developed these QACs unilaterally, without acknowledging or working with existing multi-stakeholder standard development processes, it turns out that these QACs would break existing encryption mechanisms and actually make the internet less secure. And as I said, it's a way to go around the global standard making processes. Still, EIDAS is under discussion, and if I'm up to date with developments, it seems that this QAC article will not make it into the final text. But still, my point is the proposal was there and was on the table. And now, Europe, of course, is not the only part of the world where we see developments moving one way or another in the direction of asserting a more sovereign approach over the identifiers. There have always been countries that advocated for changing the governance system to a government-led model that would give more power to governments to mandate how the internet works or who it includes. Such countries and such regions are motivated by very, very different agendas. Like Alisa that addressed you yesterday, and Marco sitting in the back, I too just returned from the ITU plenipotentiary where we saw the same old story playing out with more or less the same outcome. Don't get me wrong, we should not level Europe, and I'm not under any circumstances leveling Europe with these other regions. The starting point, the perceived sovereignty concern, as well as the intended result, very significantly differ in the case of the EU. There are legitimate concerns, not all, some are merely political. The issue is how you address them. So by putting forth such initiatives that seem to be aimed at unilaterally controlling the identifiers and the technical protocols, Europe can really help drag the identifiers in the geopolitical agenda. Take again the example of regulating the root. And I have to say, the US contemplated similar cybersecurity measures on the DNS. The slight difference here is that it was much more straightforward to carve out ICANN and the root. So again, the example for regulating the root. If one jurisdiction asserts that it has the right to regulate the root of the internet, then what is to keep another jurisdiction from claiming the same? Traditionally, the root precisely has been entrusted to the multi-stakeholder technical community for that reason, to keep it out of interstate politics, and thus to maintain one network. So let me finish by that from the perspective of the technical organization, dragging the standards, the protocols, the identifiers, that is a very purely technical function, into the geopolitical agenda can be dangerous to the very global interoperable nature of the internet. And why is that? It's because the internet at its fundamentals is based on trust. We assume that it will just work. It's unthinkable that there will not, the internet will not resolve. We take it for a given. And it is true. It generally is true that it just works. But why? Because we all agree to operate on the same protocols and standards. No one mandates anyone to use this set of identifiers. It's a matter of trust. So if legislators and different initiatives start challenging the existing governance mechanisms and supplanting them with national or regional legislative rulemaking, if we introduce multiple incompatible protocols and standards, etc., we are starting eroding this glue that keeps the internet together, the trust. I will stop here. I hope I didn't tire you, and looking forward for your comments.
Oh, the interesting issues raised. Do I see any questions? I know that I always have questions. So let other people in, but I guess not. So the thing that strikes me about your recounting of these conflicts is, where is the political impetus in Europe coming from? Like to have a sovereign DNS, to challenge ICANN's authority over the roots. Where is this coming from?
So, as I said, we are living in a very different world. Different regions and different countries around the world want to be sovereign, including digital sovereignty. The idea of digital sovereignty is one as such that comes from Europe. So Europe, in this particular Europe Commission, 5-year commission, has 10 priorities. Number 1 is green, everything green, which we forgot a little bit about with the pandemic, but we'll get back to that. Number 2 is digital sovereignty. So we want to be sovereign. The thing is, for me, that might as well, and it does make sense in different areas of digital, but it gets applied. I'll speak louder, okay?
My friend in the back.
Okay, thank you. Sorry for that. It might make sense in different areas of what we name digital, that we try to become sovereign. But when you apply the idea of digital sovereignty all the way down to the internet, that's where things get complicated. But to answer your question, I would say it's a political aspiration. We want to be digitally sovereign.
But is it like a reaction to big tech? Is it perceived as giving the finger to America, or is it just some kind of domestic politics, more nationalism, or what?
I would say a combination of all that. So you want to be digital sovereign vis-a-vis China for the infrastructure. You want to be digital sovereign vis-a-vis the US for the software, the Microsofts and the likes.
Data.
Please.
For data.
The data as well. Yeah, the data as well. And then other comments that I've heard, and I'm just reproducing for you to reflect on, is that the previous US administration did not really help in.
Really?
What a surprise. Yeah, so it gave rise to questions like, what if another US president thinks that same way and goes into the offices of ICANN and pushes the red button and Europe is out of the internet, which, by the way, technically is not possible. But, politically.
Sounds good.